You're about to witness a case that perfectly captures the tightrope between legal precision and courtroom chaos. This is State versus Michael Winquist, and at the center of it all, a web of firearms, intoxication, and a defense strategy that keeps shifting like sand. The judge unflinching, the attorneys strategizing their next move like it's a game of legal chess. But make no mistake, behind the back-and-forth legalese is a real man facing serious time and a community watching. What justice will look like when the system is pushed to its edge. At stake, 9 counts, including multiple serious felonies, a plea deal previously rejected by the court, and a renewed offer today that's, well, let's just say it walks a fine line between damage control and strategic retreat as the hearing unfolds. You'll hear offers involving reduced charges, dismissed counts, and firearm enhancements, plus a disagreement over what facts even matter. The judge calls out both sides, reminding everyone this is not about playing the odds. It's about what serves the public interest. And just when you think things are settling, new evidence surfaces, including images obtained from the victim herself. So buckle up. The stakes are high, the clock is ticking, and the courtroom is anything but calm. Who's cutting the better D land? Who's bluffing their way toward trial? Let's get into it.
I'm going to interrupt you. I relied upon the stipulated facts by the defendant. That's what the court relied on, because I cannot rely on anything else. We will go on the record in the matter 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Eugene Harrington, defense counsel, in person. Michael Winquist appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a status conference. We were here at the last hearing as it related to the plea offer and agreement that had been reached between the parties. The court rejected that offer, and now we're here for a status conference. Mr. Harrington, can you please update the court?
Judge, Mr. Schmidt has, I think as of yesterday, provided some more discovery. Some of it is on dist and some was by email today. We have continued to discuss potential plea, although given the trial date and the preparation necessary, we're getting at a point where we have to end that process. In any event, I proposed an alternative plea to Mr. Schmidt probably a couple weeks ago, and he'll correct me if my timing is wrong, where same plea as previous, amend count 1 to second degree, plea to felon in possession of firearm with respect to the shotgun, amend the count that relates to possession of a firearm, that being a pistol, amend that to allege possession of the firearm that was found in the kitchen cabinet, which was the victim's, that hadn't been charged, plus plead to misdemeanor possession of firearm while intoxicated. Mr. Schmidt's reply was, I don't think the judge will go for that. Why should she go for that if she didn't go for it before? We've had further discussions. Actually, over the last couple of days, Mr. Schmidt and I have exchanged some lengthy emails. Mr. Schmidt did mention the additional discovery that I haven't looked at yet. I have to do that, obviously. And we had another discussion yesterday where Mr. Schmidt is contemplating amending count 1 from attempted homicide to first degree recklessly causing injury. And I think I responded to that with an observation about the enhanced penalty from the original charge of second degree recklessly causing injury with a firearm enhancer. The court, Mr. Schmidt and I agree, the court made a mistake in its decision. The penalty for second degree recklessly causing injury with a firearm enhancer, the enhancer adds 5 years to that. So
Maximum possible penalty of 12 and a half.
12 and a half.
That's what I said, as I knew that.
Oh, well, okay, then.
I was well aware.
That isn't what we remember. In any event.
It enhances it from 12 and a half to 17 and a half. That was the correction.
Yeah, I think
Oh,
that's
okay,
what.
so from 12 and a half to 17 and a half,
I think the maximum penalty for an felony is 7.5 confinement, 5 years ES. The enhancer adds 5 years to the confinement portion, so it would be 7.5, 12.5 confinement,
modifier?
5 ES. Firearm modifiers.
It does not. If the statute specifically says it does not increase it by any additional time if the underlying facts related to a firearm.
No, it says, so first of all, second-degree reckless endangering safety is a Class F felony. Class F felony is the imprisonment. You're right. It's 12.5 years total.
See, I did
I
it
was
correctly.
mixing that up. So it increases it to 12.5.
Exactly.
What the court is saying, though, about the essential element thing, possession of a firearm or possession of a dangerous weapon or use of a dangerous weapon is not an essential element of recklessly causing injury.
No, but the underlying facts, what's the statute now? I don't have the modifier statute in front of me.
I don't have it in front of me either, Judge, but anyhow, you asked for the status. That's essentially where we're at. Mr. Schmidt and I are discussing. I met with Michael for just a couple minutes before this hearing. I've given him copies of the emails that Mr. Schmidt and I have exchanged. We're going to chat again. He's the one that ultimately makes the decision about this. My concern is, I don't know what your thought is with respect to potential penalty in the public's interest. I'm lost on that, Judge.
I don't have a thought. My thought is, because I can't, as Mr. Schmidt said, we can't look at a case and we can't go, okay, well, we're looking at this many years initial confinement, and so we're going to charge based upon that. My thing is my job is to review any offer to see if it is in the public interest. And it doesn't mean a set amount of initial confinement years. It's just what was offered, the second degree reckless with the modifier, as well as 1 count of possession with of a felon with a firearm and 1 operating a firearm while intoxicated. When we have 9 counts, 8 of them are serious felonies. The plea agreement as proposed didn't meet the public interest.
Let's pause for a moment, because this is where things really heat up. The judge has just laid out exactly why the previous plea deal was rejected, and it's not just about the number of years in confinement, it's about principle. Is weighing 9 total counts, most of which are felonies, against a revised offer that drops many of them in exchange for a few guilty pleas. And what is the judge saying here? That public trust cannot be traded for convenience. In other words, no matter how polished the plea deal might look on paper, if it does not serve the public interest, it is off the table. But here's where it gets even more tangled. The defense insists that Michael is only admitting guilt to the charges he believes the facts actually support. Meanwhile, the DA is scrambling to backfill evidence, some of which was just discovered trying to justify those firearm charges that the judge may not fully buy into. Quick question for you. Do you think the judge is being too harsh here, or is she doing exactly what a judge should, holding the line? Drop your thoughts in the comments. Would you accept a plea if it meant dismissing 6 serious charges? This right here is the moment where courtroom strategy meets moral responsibility. Keep watching, because what happens next might just reshape the entire trial approach.
Judge, you're relying, as I recall, in rendering your decision, you're relying on the allegations of the complaint, which I must emphasize are allegations.
I'm going to interrupt you. I relied upon the stipulated facts by the defendant. That's what the court relied on, because I cannot rely on anything else. The arguments from the state, as well as the stipulated facts from the defense, and believe me, I use word for word what was taken down by my court reporter.
Mhm.
That's what I used. I didn't use any other facts alleged that were not stipulated by the defense.
We did not stipulate anything with respect to the charges that were going to be dismissed, because there is, Mr. Schmidt and I disagree about how a jury will receive this evidence, but there are facts to support a defense to the felon in possession of the firearms, where those firearms were found downstairs in a basement behind a closet.
Counts 2 through 8, or at least 3 through 8?
3 through 8, not 2. The whole plan is that Michael's going to plead guilty to the facts, to the crimes that the facts support. Certainly count 1 as amended to second-degree reckless with the firearm enhancer. Count 2, possession of the shotgun as a felon. And now we propose count 9, which is the misdemeanor possession of a firearm while intoxicated. And Mr. Schmidt and I have talked about
That was already
something
included
different.
in the plea agreement.
I don't think count 9
It
was, but
9 months, it was.
yes, okay.
I guess my take on what's happened since then is that was Mr. Harrington's proposal. I had proposed instead to him pleading to amended second-degree reckless endangering safety at the dangerous weapon modifier, and then all of the felon in possession of firearm counts, dismiss but read in the intoxicated handling of the firearm. And then we'd run the count 2 and 1 concurrent to each other, and counts 3 through 8 concurrent to each other, because 3 through 8 are all the constructive possession ones. They're all in one location. They weren't using the commission of the crime. Count 2 was, which is why it's concurrent to count 1. In the meantime, the reason why there's additional discovery is I started checking with law enforcement, since my take on what the court's written order was is concerned about all the felon in possession of firearm charges being dismissed but read in. So I started collecting evidence about what is our evidence for that. I discovered that law enforcement had not actually sent to us, the DA's office, some of the evidence to that. That's part of the 4 gigabytes sent there. In particular, photographs of what the weapons, how they were arranged when the police found them versus how they staged them later when they were taking photos for documentation purposes. We also have obtained photos of him handling the firearms in the past 5 years. We obtained those from the victim. That was actually just today, so I don't know if Mr. Harrington has that.
I haven't looked at that. I think Mr. Schmidt has advised in the email yesterday or early this morning that discovery was available, and I haven't looked at it yet. Handling the firearms in the last 5 years, I don't think that OWI conviction felony is 5 years old though, is it?
I can look it right up.
It was 2022. I believe the oldest photo is 2023. But I have not looked at the photos myself. I'm just reiterating the summary of the photos from the investigator who told me about them this morning.
And Mr. Harrington, to answer your question, the court has to look at what has been charged with the agreement that's been extended when I'm looking at the public interest. I don't know anything about your argument that none of those firearms were even able to be in Mr. Winquist's possession. I know nothing. I go off of what has been charged initially with the facts that I have stipulated to and with what was stated in the arguments. I did not have either one state at the arguments that counts 3 through 8 could not be proven beyond a reasonable doubt in front of a jury.
And my position is there's a real question about that. There are defensible facts to counts 3 through 8. And my position always has been that Michael admits count 2 certainly, count 1 as proposed to be amended, and would admit count 9.
And it is what it is, and a jury can decide. You said that there are defenses. You can argue the defenses to the jury. The jury is the impartial body who looks at the evidence, who bases the testimony and determines credibility.
I know what the jury does.
Exactly. That's what it is. And if you are indicating that there are defenses to 3 through 8 possessions of firearms by a felon, when there have been no statements to the court that there were not firearms for counts 3 through 8, then you argue it to the jury.
That's the status of our negotiations.
All right, so I can understand, Mr. Schmidt, you offered to amend count 1 to second degree reckless. plead to counts 2 through 8, dismiss count 9, but have some concurrent and consecutives within there.
Yes.
And Mr. Harrington made a counter offer of amending to second degree, again with the modifier.
No, I haven't agreed to second degree because Michael had,
Oh,
Michael and I
first
need to
degree.
talk about that.
Or reckless,
yes.
just reckless?
My current proposal is amend it to second degree reckless with a firearm enhancer as was in the original offer.
And was it plead to 2 possessions of a firearm
2 possessions of a firearm plus count 9.
plus the misdemeanor? So we have 2 offers out there, and so it sounds like the parties are trying to work to find an agreement that may be acceptable in the public interest, or we go to trial.
Yeah. And the one peculiarity with the defendant's offer is the second felon possession of firearm charges is the only gun I didn't charge because I can't connect it to him.
The count 8,
No, it's not charged. It's
Oh,
a
it's
gun
not
that's not
charged.
referred in the complaint at all.
not even referred to in the complaint. So
That's
the
what
one
I'm
that
getting
cannot be connected to him, the one that was found allegedly in the kitchen that was perhaps owned by the victim, is not charged.
Yes.
Okay. See, now I'm having a better understanding of this case and the facts. As you stated, I have what is alleged in the criminal complaint, the stipulated facts by defense, and the arguments that were presented to the court at the hearing. That's all I have available to me to determine whether or not the plea agreement is appropriate for the public.
And I do think the agreement I proposed is consistent with the public interest, the one I've articulated today with the additional counts.
All right, so that's where we are. We have final pretrial September 4th at 1 o'clock. Are we looking at having a status or something prior to that, or we're just sticking with September 4th?
I would prefer that we have a status before that.
Your August 14th date?
Or
August 14th at 10:30, I believe you're coming back.
yes,
August 14th at 10:30, we will have another status.
Judge, you had previously suggested 9:45 might be available.
It is.
Maybe do it 9:45 because I already have 4 for 10:30.
Yes, we can do 9:45, or I can do 11:15.
9:45, please.
All right, 9:45.
Just, I'm sorry, Judge, I can't do it that day. 9:45, I already have plugged in some things, so I'll be here.
Or I can move it to the 11 slot.
No, 9:45 works. Judge.
All right, August 14th at 9:45. August 14th, 9:45, we'll have another status. Anything further?
No.
Not from me.
All right, then we are adjourned.
And that brings this intense status hearing to a close, but the case far from over. Here's where we stand. Both sides are still locked in a strategic tug of war. The defense is offering pleas to a narrowed set of charges, while the state pushes for accountability across all 9 counts, especially the felony firearm possessions. Meanwhile, the judge remains focused on a single guiding question: what serves the public interest? Additional evidence is on the table. More discovery is expected. And as we head toward the August 14th status hearing, the pressure is mounting for both sides to find middle ground or face a full-blown trial. So what do you think? Should the judge accept a deal to move things forward, or hold out for a broader reckoning? Drop your thoughts below. And if you found this case as gripping as we did, make sure to hit that like button, share your take in the comments, and subscribe for more jaw-dropping courtroom breakdowns. We've got plenty more real cases coming your way.